The second law to discuss is the Equal Pay Act of 2010. This law, employers must give both men and women equal pay if the terms and conditions of the contracts are, according to ACAS, no date, like work, which is work that is the same or broadly similar, work related as equivalent under a job evaluation study, work to be found of equal value in terms of effort, skill or decision making. This Act allows employees to discuss with other employees of different sex on the similarities of the contracts drawn up. Employees also have the right to know if their pay is made up and if the employees are eligible for bonuses and how to earn these bonuses. In addition, employees are entitled to discuss rates of pay in accordance with the Equality Act. However, employers can ask to keep employees from discussing pay rates outside of the workplace for data protection purposes. ACAS also states the equal terms can cover all aspects of pay and benefits, including basic pay, overtime rates, performance-related benefits, hours of work, access to pension schemes, non-monetary terms, and annual leave entitlements. If an employee believes they are receiving different pay, then this can be taken to their employer to be investigated. If the problem cannot be resolved informally or formally through a grievance procedure, then it can be taken to an employment tribunal in accordance with the Equality Act 2010. This piece of legislation is very important with regards to employment because it is closely linked to the Equality Act of 2010, especially with regards to the sex characteristic in general. It is also important as pay is one of the main incentives to work in the first place, as everyone should be entitled to equal pay in the workplace for the same similar job that they do. The Equality Act of 2010. The Equality Act came into force in 2010 and incorporates some previous legislation such as the Race Relations Act 1976 and the Disability Discrimination Act 1995. The Act is in place to ensure that employees are treated in a fair manner that complies with the law. There are different types of discrimination that will be in effect in the workplace, such as direct discrimination, indirect, perceptive, associative, harassment by others, and victimisation. The legislation covers aspects of the following protected characteristics: age, disability, gender reassignment, marriage and civil partnership, pregnancy and maternity, race, religion or belief, and sexual orientation. Out of the three legislations that will be talked about in the following audio, this is probably one of the most important in regards to employment, because it covers such a large scope of basic human rights and it ensures that every single person, regardless of personal orientation or circumstance, is treated equally in the workplace and has equal opportunities with regards to gaining a job or earning promotion. The following example provides a case of direct discrimination against sexual orientation, and this is as follows. Paul, a senior manager, turns down Angela's application for promotion to a supervisor position. Angela, who is a lesbian, learns that Paul did this because he believes the team that she applied to manage are homophobic. Paul thought that Angela's sexual orientation would prevent her from gaining the team's respect and managing them effectively. This is direct sexual orientation discrimination against Angela. As of 2014, the rules and regulations for pursuing a tribunal claim is changing. According to The Guardian, from the 6th of April, new rules come into force designed to reduce your number of claims taken into employment and tribunals. Rather than taking a case against your employer straight to tribunal, you'll have to notify ACAS first. The notification to ACAS is voluntary for a month, but becomes mandatory from the 6th of May, which is already in effect as of now. The process will work via making a claim to ACAS, and this will be assessed and possibly resolved through the employer themselves. If this is not the case, then ACAS will issue a consolation certificate. Then the claim can be lodged and taken forward to a tribunal. These changes to the legislation are very important, as this is the primary way that employees can make claims against the employers for any grievances within the workplace. Now that it has to be done through ACAS before, the next step can be taken. It should make the tribunal process less confusing for the employees and the employers and save a lot of time as well.